Hello, my name is Donda Pungo, and representing ARP, we're talking about end-of-life legal planning. And it's all about our campaign, all part of our campaign, Redefine Possible. And our guest today will provide information on the importance of end-of-life planning. He's Reverend Attorney Aaron McLeod. Did I say that right?
Yes,
McLeod.
sir.
Aaron McLeod is the Executive Director of Special Projects at Trinity United Church of Christ in Chicago. I'm your host, Donda Pungo. Aaron has all of the degrees. You have a law degree. He has a master's in divinity, and he also is an expert when it comes to estate planning. He's a licensed attorney in the state of Illinois. Now, first, before we jump into the specifics of what estate planning is and what it means to our folks here at ARP, tell us about your organization and what you do there.
Well, I am involved in a partnership with Vitas Healthcare Corporation, which is the largest end-of-life care healthcare corporation in the country, Trinity United Church of Christ, and the Center for Practical Bioethics. In essence, within this triumvirate partnership, we've come together to provide advanced care planning for the African American community in particular in Chicago. So with the church, with the corporation, what we've done is we have led that congregation in particular through 5 modules to begin to understand the dynamics of planning at the end of life. And it's an intergenerational conversation that involves sometimes people who are older at the end of life, but even younger people at the end of life, because the time span of life has nothing to do with age. When it's your time, it's your time. And so within that, we provide these modules. We talk about estate planning. We talk about advanced directives, which is medical in nature, to ensure that families and communities are well endowed with necessary information, that they're well prepared for the inevitable, that we will transition.
We don't often think about, when we talk about transition, about the age factor, right? So how early is too early to think about estate planning?
It's never too early. I would say the appropriate age would be 18 years old when you reach the age whereby you can make your own decisions, especially if you're an 18-year-old or a young adult who has property. Then you can begin to make your planning about how you want that property to be handled when you can't manage it yourself, or when you're no longer here to take possession of your property and who that property now will go into the possession of.
Let's jump right in. Talk to us about what estate planning really is.
Estate planning really deals with this notion of preparation. Donda, my mother is now retired, a former teacher, administrator, and now she's a retired church musician. And she would always say that an ounce of preparation is worth a pound of cure. In college, when pledging a fraternity, I'm an Omega man, when we went to see the Big Brothers, they would always tell us that being prepared would cause us to have a better night, if you will. All of that to say is when you talk about estate planning, you are executing legal documents that help people to understand how you want your financial, your property, and your health affairs to be handled when Donda or Julie or Billy can't articulate that themselves. So when we talk about estate planning, it's talking about being good stewardship, being a good steward over the property that you own. Who is going to be in possession of your property at the time of transition? How will they maintain this property? Who will be responsible for maintaining your property when you may not be in a position to do it yourself? So the planning ahead of time allows you to articulate in advance how you want those affairs to be handled versus the government or a close third party or a random third party coming in to make those decisions for you.
And what we're seeing right now is a list of some of those things that estate planning takes care of. Who will receive your property upon your death? What will they receive? When they'll get it? And how they are to receive it. Now, in order to even begin this conversation on all of those things, what are some of the documents that we need to have in front of us?
What I would call a 6-prong estate plan, particularly for people who live in the state of Illinois. If you live without what we call a writing, Donda, that's without minimally a will, all right? But more importantly, a trust. If you don't have a simple writing articulating how you want your property to be given up, you die what we call intestate. Now,
what is that?
Intestate means that you don't have a testament.
Okay.
So it's another way of saying without a testament or without a writing.
Got it.
So when you die intestate, we apply what we call the common law, which are a common occurrences or transactions that we glean law from. So very quickly, Domite, if I'm driving and I rear end you with my truck, who's liable?
You're liable.
I'm liable.
Yeah.
We know from those recurring circumstances, the law says that if I don't have good following distance,
Yeah.
I'm liable.
Right.
So if you don't have a writing, what we do is that we disseminate your property to your next of kin. If you're survived by a spouse, if you're not survived by a spouse, your property is split up in equal shares amongst your children. No children, no spouse, equal shares amongst your siblings. No siblings, a next of kin, a cousin. What's the problem with that, Domite?
That was going to be my first question. What's the problem with that?
It seems like it's already solved.
Yeah,
but
yeah,
the problem is this, Domite, you have not exercised your right to say how you want that property to be disseminated.
Well, there's a really big example of why that's a problem. We saw that with Prince, right? So
Exactly.
Prince passed away. We don't know what's going on with his estate. You know, there's been a feud between his sisters about who should have what. In situations like that, when you have common law, you know, a lot of people talk about this thing called a poor man's will or a Bible will or a document that, first of all, what is a poor man's will? Have you heard of it? And why is that not the way you want to go if you're talking about estate planning?
In essence, it's a simple will that you can write on a napkin, piece of paper that says, I, Aaron McLeod, want my house, my stash of cash, and my mattress to go to my son Thompson, and to my sister Joy, to my wife Deidre, and they get so many allotments, and I sign it, and then Domite signs it as a witness, and then Sarah signs it as a witness. So simple writing, two independent witnesses who do not inherit. The problem with that, Domite, is that it doesn't provide any protections at law or through more sophisticated instruments. And when you talk about, you know, this whole notion of what Prince went through, the sad part is Prince had some dynamic assets.
Yeah.
The brother was loaded. He has intellectual property that exceeds the lifetime of his life, but more importantly, that is growing in value in light of who he was as an individual. And for it to go to probate court, to have a judge opine who's the next of kin and who gets that property is not a good use of time. It's not a good use of money, and it's costly. And so how do you avoid that? So the opposite of dying intestate minimally would be a will, the Domite. All right, and so I first learned about wills as a kid, watching soap operas with my grandmother down in North Carolina. It would be hot outside. She would call us inside so we wouldn't get this proverbial heat stroke, right? But what we always saw is that you had a protagonist character who was larger than life, who would call on an antagonist character who was normally young and rambunctious and say, I'm writing you out of my will. All right? And that's how it happens. It happens in our family. Here's the problem with that. When you die intestate without a writing, as well as with a will, you go to a very, very, very bad place. Not hell, but the second best place to hell, and that's called probate court. When you go to probate court, we put on notice that you have died. We write up in the newspaper. Your debtors, or the people you owe money to, your creditors, have a chance to put a lien on your estate. They get paid first. What's left over goes to your attorneys, but more importantly, to the heirs of the estate. Now, what did wealthy people in feudal times in England do? They created what we call the living trust, to pass your property on to your heirs without any encumbrances, without any problems, so that they could take their property. And so with that, you become, you know, what we call a trust fund baby. That's not for somebody who's obnoxiously wealthy or, you know, obnoxiously arrogant or rude. It's for someone who owns property, who wants to send or give their property to their heirs, their descendants, their children, without any problems. So the way to go is not necessarily one, being intestate, two, the will is okay, but the big doozy, the trump card is the trust.
And we see quite a few examples of ways to plan your estate. You have wills, you have trust, you have land trust, real estate, power of attorney. What is real estate power of attorney?
Great question. All right, in Illinois, we have some issues in our state with our state budget, but one of the great attributes of being an Illinoisan is that you can settle or incorporate what we call a land trust. Only one of 6 states where you can put a piece of real estate only multiple pieces of real estate into a land trust whereby a third-party title company, Chicago Title, a Stewart Title, whatever one you have here in the city, holds the property for you in trust for a nominal fee on an annual basis. What does that do? It makes you judgment-proof. So let's go back to our hypothetical. I rear-end you. You get an attorney. They're going to sue me because you have $10,000 worth of property damage to your car. But you're also what we call a pre-existing eggshell plaintiff. You have a pre-existing condition. So not only do you have property damage, but you have health care damage to the tune of $250,000. Your average car insurance is about $100,000. So now I owe you $150,000. So if I'm not $150,000 liquid, which arguably most people should not be when you look at the time value of money, you want to invest property or invest in things that hold greater value than the value of money. So to that end, most people's greatest investment is their real estate. So Adomity will come and put a lien on my house, and when I get ready to sell my house, I have to make you whole first, and then what's ever left over I get. But if you sue me, you won't get anything because I have a land trust.
Right. Okay.
I own property, but I don't own property.
Because it's protected.
In the trust.
In the trust. We talked about a lot of stuff. 312-738-1060 is the connection. Our guest, of course, is Reverend Aaron McLeod. We're talking end-of-life legal planning. Again, I'm your host, Domity Pungo. We have a caller. Caller, what's your question? Caller, you there? Let's move on. We're going to call back, please. We think we lost you. Again, the number is 312-738-1060. Again, Reverend Aaron is talking to us about end-of-life legal planning, and there are quite a few examples of estate planning and what those look like. So we have wills, we have land trusts, we have pour-over will, we have living wills. You talked about real estate power of attorney, and there is healthcare power of attorney. What is healthcare power of attorney?
Okay. The power of attorney in general is when you give somebody the right to act as yourself when you're alive, and you can't not take out when you can't act as your own agent, either for property or health care. So you're appointing a person who you trust to carry out your directions on how to write a check, how to purchase property, how to buy, sell stock. More importantly, on the healthcare side, this person is following your directions on how you will be treated when you can't make healthcare decisions on your own. It can be the same person, but in Illinois, it has to be two different instruments. So when you go into a hospital, sometimes a person will be what we call the durable power of attorney, or the power of attorney for property. And they'll come in, they'll say, "Doc or nurse, I'm here to make decisions on behalf of my mama. I'm the power of attorney for property." And the nurse will say, "Sir or miss, if you don't have a healthcare power of attorney, we cannot honor this." And then we start to look for surrogacy laws to find out who's the appropriate person to make the healthcare decision at that time.
What you're really getting into is the wishes of the person who has passed away, and we're going to get to that in just a moment. But I do want to give an opportunity for callers to call in 312-738-1060. I think we have a caller on the line. Hopefully you got back in. Caller, are you there?
Hi, my name is Keisha.
Hey Keisha, how's it going? What's your question for Reverend Aaron?
So when is a good time to actually do estate planning in terms of age? And then when do you recommend you actually change kind of your will and those things when you're going through different life transitions?
Yeah, he said as early as you're able to make decisions at the age of 18 and when you start to own things. But yeah, when to the second piece of that question.
Yeah, we call it the 4 Ds, all right? That's when somebody dies, all right? And that's not the decedent because they're dead. That's the next of kin of the decedent.
Ah, okay,
all right?
okay.
When you have a divorce, all right? When you have a diagnosis, or when you have a change in what we call your decisional capacity. Those are the times which you should edit your estate plans.
Well, if you have a change in decisional capacity, like maybe Alzheimer's would be an example of that or something like that, how are you then able to even, you have a change in decisional capacity, so how are you able to initiate this process of altering your estate planning?
All right, so that happens through what we call probate court through guardianship. So if Miss Emma is now 85 years old, she had a power of attorney, and say it's changed 3 times within the last 3 weeks because her children are feuding, one of those children or the guardian or the public guardian will come in and petition the court for someone to become her guardian of her person, which is her health care,
Okay.
and the guardian of her estate, which is her finances. You go before a judge, there's a hearing, you have a hearing on the facts of why you think you're the best person to become the person's guardian. You put the family members on notice. They can come in and provide testimony as to why you would be fit or why you would be unfit. Once the judge appoints you, you have to be bonded with insurance, and you come back in on an annual basis to provide a health as well as a financial report. If there's any malfeasance, you'll be liable civilly and potentially criminally as well. But that is the most rigid and the most reliable form of what we call agency work. So when we talk about power of attorney, it's agency work. You're appointing an agent, either yourself or by the court, to represent you to handle your affairs.
All right, we're here with ARP's Redefine Possible. You're talking to end-of-life legal planning professional expert. Can I call you expert?
To God be the glory.
Reverend Aaron McLeod. The number is 312-738-1060. I believe we have another question. Caller, are you there?
Hi, how are you? Wonderful show.
Thank you.
My question is about trusts, and if I were to grant a trust now, what is the best way to, I guess, elect a trustee? I mean, would you suggest that that trustee be somebody I actually trust, or if this is going to be a bank or an institution that provides trustee services?
Or a business partner or something like that. Is that what you're getting at? Yeah, I think we lost him. But yeah, but that's a very good question, because we think family initially, but there are people who are financial experts who you may say this might be the better person to trust. How do you evaluate that?
So Domity, when you put your trust together, it will be the Domity Living Trust, okay? Mm-hmm. You would be the first trustee, not necessarily an institution within the living will. A lot of times people get mixed up that a living trust is an account versus a legal instrument. So the trustee is the individual. Then we have what we call successor trustees. That would be your next of kin. It could be a spouse, a partner, or a sibling, or a trusted person. You can appoint an attorney or an accountant, preferably someone who carries licensure and is regulated by a state agency to do that work as well. To the caller's point, if you wish, you can also secure trust services by a financial institution to manage money as well, particularly if you're dealing with underage individuals who are the beneficiary of a trust and you want to manipulate those markets to get the best return on money. But it's not the rule of thumb that you have to have a trustee outside of yourself. The principle of the trust is the first trustee.
I think about, when you talk about living trust, though, and you kind of redefine the way it's built in my mind, right? Mm-hmm. Can a living trust be used as a wealth building instrument as well, or is this specifically for estate planning for your posterity?
Both. It's for estate planning, but also wealth building instrument when you look at the types of trusts that are out there. So if it's a beneficiary trust for a person, a young person, definitely wealth building. You allot them money that they can't touch until they're a certain age or until they reach certain milestones, so until they're 35, until they graduate from college. That's helping them to grow money or grow their assets or preserve assets to a time where they're mature enough to deal with it. When you look at the whole notion of being an estate planning tool versus an investment tool, let's go back to the land trust.
Okay.
So with the land trust, minimally to have a land trust, you have to have one piece of property in there. Mm-hmm. But another benefit of the trust, land or living trust, is that it promotes anonymity. It's not about what you own, it's about what you control. You don't want everybody knowing what it is that you own, because then you become susceptible to lawsuits or people harassing you for what it is that you own. So on the land trust front, you can purchase multiple properties in that trust as long as it has what we call the same beneficiary interest. So my beneficiary interest would be to from my wife and myself to my son. All right. So as long as me and my wife continuously buy properties where the final or the secondary beneficiary interest is my son, we can create what we call a REIT, a real estate investment trust, where we're buying property through that trust, not through Aaron, not through Domity, but through the trust. And nobody knows what it is that I own. Nobody knows what it is that you own. And we create or we amass wealth that way.
Keep those callers coming in, because that was a great question. It spawned off into a lot of topics that I don't think we think about when we really think about estate planning. Again, we're talking to end-of-life legal planning specialist, Reverend, I give you a new title each time, expert specialist, all that good stuff, Reverend Aaron McLeod. 5 wishes, 5 things that you want to think about when you talk about estate planning. We're talking about who you want to make healthcare decisions for you when you can't make them, the kind of medical treatment you want or don't want. What are some examples of that?
Okay. Let me just make a distinction. 5 wishes is what we call a advance directive. Advance directives are medical documents, are medical instruments that provide direction to healthcare providers about how you want to be treated.
Okay.
You can say that you don't want death-delaying treatment. So, for example, if you have, God forbid, stage 4 cancer, and death is what we call imminent, it's going to happen quickly. You may not want to be put on a respirator machine that keeps you alive. Why? Because someone has to pay for that. It's exacerbating your estate. We talk about your estate, it's what you own, okay? And so it also says, who do you want to make decisions for you when you can't make them yourself? That's another agency question.
Right.
So 5 wishes is a more welcoming document. It doesn't have as much legalese, but it helps patients, but more importantly, families, social workers, end-of-life care specialists, funeral homes help prepare for the inevitable last rites of a person. So we encourage people to fill that out. It takes a signature. It penetrates here in Illinois. It penetrates in 26 states. Doesn't penetrate in all 50, but it's a good document to have.
Walk us through the rest of them. How comfortable you want to be. What do you mean by that? What are some of the provisions that people are thinking about when they're going through serious health issues?
All right, so we have this form called the Do Not Resuscitate Order. It says that you don't want cardiopulmonary treatment, CPR. So that doesn't mean, Dimitri, that if you are out running the Chicago Marathon and you run out of breath, that you will not be resuscitated.
Okay.
Does not apply to you. If you're suffering from a terminal illness, stage 4 cancer, COPD in the final stages, and death is inevitable, you have a prognosis of a year or less to live, the pain of someone providing CPR of my size or your size on your chest when you barely weigh 100 pounds, you're frail, is just excruciating. What you're electing to do is say that you're going to die of natural causes when death is imminent, when it's inevitable.
It makes me think about, though, especially with you being a reverend, right? We know that death is a taboo subject amongst most communities, but specifically in our community, in the Black community. And I think about religiously, you know, most people, if you want Big Mama to be here, you know, so if she's on that, you know, she has that, she might not have that DNR option, but you're making that decision, we're going to continue to try to resuscitate, we're going to continue in prayer. You know, how do we have these difficult conversations with our loved ones when death is such a taboo topic in the Black community, and when you think about it from the lens of, you know, people who are highly religious and may have some strong views on the way this process should be handled? How do you start that conversation?
We have to be real and upfront. From ashes you come, from ashes you shall return. That's the Ash Wednesday blessing that we give in the Protestant denomination in which I serve. More importantly, any human being will be birthed through a natural conception between a man and a woman, and they will transition via death. Unless if you're Jesus Christ, Superman, or Osiris. So we have to begin to deal with the reality that if you are actually a human being, you have breath in your body, eventually it will come to an end. We encourage people to do or follow a program which we call at Vitas, get your house in order. Have the conversation. The problem is this. What will happen is you'll be at Mercy Hospital, you'll be at University of Chicago, and Big Mama is, you know, unresponsive, and a healthcare decision has to be made. Big Mama has 10 kids. 5 of them get along, 5 of them don't. The nurse comes in and we're looking for someone to make a decision. And what is the nurse doing? She's mediating a family fight. Because Big Mama didn't handle her business by talking to her children and saying, this is how I want to be treated. Let's write it down, let's sign it.
Another difficult conversation really quickly here. What are some resources we can use to find an attorney who has our family's best interests at heart? Because it's just as difficult talking about death, it's talking about business and the business of estate planning and end-of-life planning. How do we find an attorney we can trust?
AARP. will find you a referral service through their state offices. The Cook County Bar Association, that's a historically black bar association here in the city of Chicago. The Chicago Bar Association, the Illinois State Bar Association, the Asian Bar Association, the Hispanic Bar Association. There are entities here that can refer you services, refer people or professionals to help you in this arena.
Perfect note to end on. You can find out more information by going to aarp.org/caregiving. I'm your host, Doma T. Pungo, and our guest, of course, was Reverend Aaron McLeod. Thank you so much for being a part of Redefining Possible.
Thank you.
Thank you so much.